Hi, my name is Jamal Jackson, and I am the CEO and Managing Attorney of Jackson Corporate Law Offices. This is the third and final session of our three-part series covering corporate branding and trademarks. Now, as one final reminder, these are the objectives for this three-part series. Now, in the first part, we went over what is a trademark. We learned how to search for availability of trademarks, and we went over identifying the different levels of trademark protection. In the second session, we discussed the actual trademark application process and what do you need to gather, what kind of information do you need, how do you identify the strength of your trademark. So there's a strength of, there are different levels of trademark protection, and then there is the strength of your trademark. So part two went over the strength of your trademark. Now today, what we are going to discuss is how do you maintain that protection? What steps do you need to take in order to ensure that once you receive protection for the trademark, in particular federal protection for your trademark, how do you maintain that protection? And then finally, we're going to talk about one of the real dangers of failing to federally register your trademark. Now, when you think about maintaining protection, these are the common things that people do and that lead to a loss in trademark protection. So you see abandonment, not actively enforcing rights, naked licensing, not keeping up with or following up on the filings, and then misuse or genericide. So the first thing we're going to look at is abandonment. The USPTO defines abandonment typically as failing to use the mark for 3 or more consecutive years. The next thing that will jeopardize your trademark protection is not actively enforcing your rights. Now, after you register your trademark, you have a duty, you have a responsibility to enforce those legal rights. As the saying goes, if you don't use it, you lose it. And that is one of the claims that's being made in a current case taking place in Illinois, and that is the, as stated here, the Chicago mixed popcorn battle. Now, that is the case in which a St. Paul, Minnesota-based company named Candyland Inc. is suing a few local Illinois companies based on their use of Chicago mix as it relates to popcorn. Now, the company Candyland Inc. registered Chicago mix as a trademark back in 1992, and they're asserting that two Illinois-based companies, one being the owner of Garrett's Popcorn, and anyone who's ever been to Chicago or knows about Chicago, they understand the importance of Garrett's to the Chicago culture and community. And so they're trying to say that these local or these Illinois-based companies have infringed upon their trademark, and so they're bringing a suit. And one of the counterclaims is that the St. Paul-based company Candyland Inc. has forfeited their rights based on their failure to enforce the rights for such an extended amount of time. Now, again, the trademark was registered in '92. The Illinois-based companies have been using this name Chicago Mix at least since the early 2000s, and Candyland Inc. has not done anything to enforce those rights, or that is what is being alleged in this case. And the suit was brought last year and is still pending. So understand that when you do have a trademark, when you've completed the application, you have a duty and a responsibility to police its use and to enforce any rights that you have based on a third party's infringement of that right. And then the next thing is naked licensing. And so this is giving out licenses without putting parameters on its use. You don't have regards or qualifications as to the standards of its use, and you allow people to pretty much use it in any way that they see fit. Now, there are certain filings that you have to maintain and keep up with after you finish the application process, the initial application process. So you have to file what's called a declaration of use between the 5th and 6th years after the initial registration, then between the 9th and 10 years, and then every 10 years after that. Failure to file a declaration of continued use could result in your trademark being terminated. The next one is genericide or misuse. Now, this is the use of a mark that strips it of its indicator of goods or services. This often happens when people widely use a name, and that name no longer really associates a good or service to a particular company, but becomes the general term that's used to identify a certain good or service. So the typical examples are aspirin, dry ice, and escalator. Now, the dangers of not registering your mark. This is one of the truisms that is that we often speak about in regards to people who come to us and ask us if it's worth federally registering their trademark. And this is a story about Burger King. And everybody knows the name Burger King, but what you may not know is that the Burger King that's currently being shown is not the Burger King that we know today. And so this story is going to highlight how if you fail to federally register your trademark, you may put yourself in a position where you allow a third party to limit your ability to expand and to use that trademark in the way that you want. Now, in 1952, Gene and Betty Hoots purchased what was called Frigid Queen at the time in Mattoon, Illinois. They changed the name in 1957 to Burger King and then registered a state trademark for Burger King in the state of Illinois in 1959. Now, also in 1959, Instaburger, which was a Florida-based company, changed its name, was purchased by a group of investors and changed its name to Burger King. Before the purchase happened, back in 1958, Burger King of Florida filed a federal trademark, which didn't actually get approved and come through until the early 60s. I believe it was 1961 that the application went through. But one of the things that you'll note is that it doesn't matter when the application is finally approved. All that matters is the submission date, because that is when your rights are retroactive to. So the timeline goes, the Mattoon, Illinois-based company registered a state trademark of Burger King in 1959. The Florida-based company registered the federal trademark of Burger King in 1958. Now, in 1961, the Burger King of Florida opened its first store in Illinois, in Skokie. And by 1967, it had expanded to 50 stores in the state of Illinois, and the Illinois-based company, which had the state trademark of Burger King, sued the Florida-based company in a state court of Illinois. Well, then the Burger King of Florida countersued in federal court and claimed that their rights were superior to the Illinois-based company's state registered trademark. Now, what was the overall outcome of this situation? Seventh Circuit Court of Appeals stated that federal law trumps state law, which it does every single time. So in that, it says that the court stated that the Illinois-based company the federally registered trademark trumped the state registered trademark, which essentially rendered the state registered trademark useless. And what ended up happening was the Illinois-based company's trademark was reduced from a state registered trademark essentially to just a common law trademark, which, as we went over in part one, a common law trademark gives you protection within within a certain geographic scope, which is typically determined by a reasonable radius of distance within where your operations are. So the result was that the Burger King of Mattoon, Illinois is limited to a 20-mile radius. So they cannot open up another Burger King outside of the 20-mile radius in which that original Burger King was established. Now, the Burger King of Florida, because they went on and filed, or because they went ahead and filed a federal trademark, which trumped the state-level trademark of the Mattoon, Illinois Burger King, they're able to expand nationwide. So the Burger King of Florida came in, and although they were not the first to use the name Burger King, they filed federally first, and they were able to limit the rights, the ability of the Mattoon, Illinois Burger King to expand into different regions. So the moral of the story is you don't have to file a federal trademark, but if you feel that you are going to be expanding and you feel that you don't want to be held to operating within just a small radius, then it is definitely a necessary step that you should take. Outside of that, you're going to either receive, again, a cease and desist letter if you try to operate outside of your bounds, or you're going to run up extremely high legal bills in trying to assert your rights in regards to your state or common law trademark. So if you do have a company in which you feel that you want to expand, especially if you have a digital-based company, or if you want to open up stores in different states, it's extremely necessary for you to explore the option of federally registering your trademark. And this is the danger of not registering your trademark, allowing somebody to limit what you can do under the trademark that you spent so much time, effort, and money to build. So again, my name is Jamal Jackson, and this has been a three-part series over corporate branding and trademarks. I hope that this series has been helpful and that you've received some valuable information. Again, all of my contact information is on this slide. If you have any questions, want to have a follow-up conversation, please feel free to email or give me a call. We also invite you to check out the website, www.jacksoncounsel.com. We have more resources there that you can look at. If you're a business owner, it's extremely important that you have professionals on your team and in your corner who can help you create sustainability and position yourself for the growth and success that I know that every business owner wants to have. I hope that you all reach out, and I hope that you all stay tuned because we will be uploading more videos in the near future. Thank you, and I hope you have a great day.